Hi, I'm Catherine Fry of Offit Kurman, Attorneys at Law. This segment deals with medical marijuana and its impact on the workplace. What do employers need to know about this hot topic? In 1937, the federal government outlawed marijuana use. In the 1970s, states began to decriminalize use. The law and public opinion on marijuana have evolved significantly since 1996, when California became the first state to permit the use of the drug for medical purposes. 32 states and Washington, D.C. now allow medical marijuana, and 10 states and D.C. have legalized recreational use. Some 62% of Americans say cannabis should be legal, double the number that favored legalization in 2000, according to a 2018 Pew Research Center poll. Companies should pay serious attention to legal protections for employees' medical marijuana use in light of recent pro-worker court rulings. Employers have to balance their interest in maintaining drug-free workplaces, abiding by state and federal laws, some of which protect employees from discrimination based on disabilities, which they may have, and use marijuana to treat. Other laws forbid employers from discriminating against employees who treat medical conditions with marijuana. Prior to 2017, courts rejected worker lawsuits challenging adverse employment decisions as a result of medical marijuana use, including state high courts in California, Washington, and Oregon. But that year, a Rhode Island state court ruled that a fabrics manufacturer couldn't refuse to hire a paid intern who legally used medical cannabis, even though she wouldn't pass a drug test. A Delaware state court at the end of 2018 allowed a former Kraft Heinz Food Company employee to move forward with his lawsuit, alleging the company violated the state's medical marijuana law by sacking him for a positive drug test. That ruling followed decisions in 3 other states in favor of workers who either were fired or not hired because of their medical cannabis use. Delaware is among the 13 states as of early 2019 that have anti-discrimination protections in their laws specifically for medical marijuana patients. Some of the other states with such safeguards are New York, Pennsylvania, and Illinois. A federal court in Connecticut ruled in 2018 that the state's medical marijuana law prohibited a healthcare company from rejecting a job applicant who failed a pre-employment drug test. As you can see, this complicated patchwork of state requirements makes it difficult for multi-state employers to adopt a single approach. For example, Delaware has a typical non-discrimination law called the Medical Marijuana Act. Under that law, qualified cardholders must be free from employment discrimination in hiring, firing, or other terms and conditions of employment based on either 1, the person's status as a cardholder, or 2, a positive drug test, unless the employee used, possessed, or was impaired by marijuana on the premises of the place of employment or during the hours of employment. So a cardholder refers to someone who has been issued a card by the state of Delaware certifying that they are taking medical marijuana as prescribed and dispensed by a licensed location. Be careful, an employer could still be liable for the negligence or malpractice of its employee who undertakes a task while under the influence. This is why some employers want to drug test their employees. Early medical marijuana laws focused on compassionate use for terminal patients, but over time, laws have shifted to broaden the conditions eligible for a prescription, allowing people to manage symptoms and remain in the workforce. But employers are still free to set up drug testing programs, and employers can dictate that patients aren't allowed to medicate on the job, even if it doesn't impair their performance. Caution is the word here. There are several situations in which testing can occur. Pre-employment for everyone, after an accident, on reasonable suspicion of being under the influence, to test fitness for duty when someone returns for work, and random testing for everyone. The nature of the applicant or employee's job is important when a company is deciding whether to test, and if so, how, with safety being the key consideration. If someone's using knives, working with hot equipment, or carrying items which if dropped could injure someone, these are positions in which testing might be smart. Given the complex legal landscape and the changing attitudes towards marijuana use, employers have taken different paths. Some companies have chosen not to test for cannabis at all, while others only test employees in safety-sensitive positions or provide job accommodations to medical marijuana patients. Testing pre-employment can reveal whether the applicant is using illegal drugs. However, the problem with testing for marijuana is the fact that the blood test will not show THC, the active ingredient, but will not show when the THC entered the body. Therefore, someone can test positive because they took it 4 days ago, over the weekend, and not be under the influence at work at all. This is completely different from alcohol, as we know. Post-accident testing and testing on reasonable suspicion can be problematic for the same reason. But if you're going to test someone, it's very justifiable to test after an accident. So-called reasonable suspicion can look like discrimination if you're only testing certain people. If the person is a card holder, it's not illegal for his blood to show the THC. If someone has a legal prescription for marijuana, all you as the employer can really do is to make sure that the person seems to be functioning at the level that's needed to perform the job. Your policy should prohibit use at work, possession or sale at work, or being at work under the influence. It should require anyone who believes that they can't safely work due to the effects of a prescription medication, including marijuana, to call out that day. Be cautious of the potential Americans with Disabilities Act issues here. Employers should confirm whether positive drug tests are connected to legal medical use before taking employment decisions. Not only are workers in some states covered by medical marijuana discrimination laws, people using medical marijuana may have a disability under the ADA. An employer can't fire someone because he has a disability, and drug testing might reveal this disability. This can also happen when an employer drug tests and the test reveals that the employee is being treated for drug addiction, such as an opioid addiction, with other drugs, which are found in the bloodstream. If a worker seeks an accommodation for medical use, employers should request the appropriate medical certification and mandate that the employee will refrain from on-duty use or otherwise not pose a risk in the workplace. But taking an adverse action is not recommended in that situation, no matter how unhappy this makes the employer. My company has a zero-tolerance policy with respect to marijuana, and my employee tested positive for marijuana. Can we fire her? This is an example to go through. Can we discipline or terminate her? It depends. If the employee doesn't have a prescription, there's no potential protected status, so the employer is free to discipline or terminate. Be aware that the employee complains to the EEOC. If they do so, the EEOC will look at whether the employer is firing only people of color who test positive, or only men who test positive, etc. This could be an example of a neutral policy with a disparate impact. If the employee does have a prescription, it might still be okay to discipline. Was the employee under the influence at work, or did she possess it at work? The statute doesn't protect this behavior, but the timing of the ingestion may be hard to tell, as we discussed earlier. If there's any doubt, run it past your attorney. You don't want a lawsuit either way, whether it's because the employee caused an accident at work or whether it's because there's a potential discrimination issue. These cases can be tricky. Under the Americans with Disabilities Act, courts may require employers to consider whether there's a reasonable accommodation that could allow a disabled employee with a marijuana prescription to perform her job. The company's rep may be required to engage in an interactive process to determine if an equally effective alternative exists, or making an exception to the drug policy and allowing a person to use at work to the extent it's not affecting his ability to work might have to be made as a reasonable accommodation. In order to avoid making a reasonable accommodation, the employer would have to show undue hardship to the business. A final point about drug use at work is the fact that a person who seeks drug or alcohol addiction treatment is considered an individual with a disability under the ADA. Allow a person in treatment to work unless they can't perform the essential functions of their job. Make reasonable accommodations, such as allowing them to change shifts in order to attend an AA meeting. Someone in recovery and returning from treatment also has this legal protection.